Welcome to Atheists Talk. I'm your host, George Kane. Christians frequently assert that America is a Christian nation, but merely a numerical preponderance doesn't imply that Christianity is preferred by government. As atheists, we support secular government and do not believe that government should take any religious identity nor the law. Tonight we'll discuss current laws and court rulings that define the authority of government to support or encourage religion. My guest tonight is the president of Minnesota Atheists, August Berkshire. Welcome, August.
Thank you, George.
So, let's begin, August, with the Constitution. How is the separation of church and state defined in the U.S. Constitution?
Well, in the U.S. Constitution in Article 6, and a lot of people don't think about this, it says, this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. In other words, if we were a Christian nation, the Bible would be the supreme law of the land. But no, the Constitution says that it is the supreme law of the land. So that's an important point to make. Mm-hmm. Well, moving on to later on in Article 6, it says, no religious test shall ever be required as a qualification to any office or public trust under the United States. So there's no religious test. So again, if we were officially a religious nation or a Christian nation, there would be some religious tests, but no, it specifically says there's no religious test to hold office or public trust.
Or government might even define religious offices.
Right.
As in England.
Yeah. And then finally, of course, what we're all familiar with is the First Amendment. Mm-hmm. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Originally applied just to the federal government, but through the 14th Amendment now applies to all the states as well. So we have some pretty good basics in the U.S. Constitution to protect separation of church and state.
Okay, does the Minnesota State Constitution add anything to that?
Yeah, that's interesting. There are a number of states that go beyond kind of the vague generalities that are in the U.S. Constitution and have more specific instructions. And Minnesota is one of those. In the Minnesota State Constitution, Article 1, Section 16, it says, nor shall any money be drawn from the treasury for the benefit of any religious societies or religious or theological seminaries. So that's pretty explicit, no money to religious schools. Mm-hmm. And then in the Minnesota State Constitution, Article 13, Section 2, it says, in no case shall any public money or property be appropriated or used for the support of schools, wherein the distinctive doctrines, creeds, or tenets of any particular Christian or other religious sect are promulgated or taught. So this is getting into areas like the charter schools. If we're going to have publicly funded charter schools, you can't be teaching religion in a devotional sense. You could have a comparative religion class, mm-hmm. but you cannot have like a Catholic school be funded with public money. It's very explicit in the Minnesota State Constitution.
Okay. Now, these points are established constitutionally, but they're pretty vague, and there are a lot of areas in which religion and state come into conflict or entanglement. Mm-hmm. Is a practical matter. So the courts have had to give guidance. Now, is there any general guideline the courts have provided for judging when government entanglement with a religion is unconstitutional?
You're right, there are always gray areas, and the courts have to be the ones to decide, and ultimately the U.S. Supreme Court. Tonight we'll be discussing a lot of these cases, and I used for my reference a website called oyez.com. You know how they open the Supreme Court, oyez, oyez.com. I want to give them a plug because they provided a lot of really good research. So the general guideline is a case called Lemon v. Kurtzman from 1971, and that established what's commonly known as the Lemon test. And in this case, the Supreme Court said that for government action to be constitutional, it has to pass 3 different tests, a three-pronged test, and it has to pass all 3 prongs, not just 1 or 2 of them. Or if it violates any one, then it's not constitutional. The 3 stages are that the government action has to have a secular legislative purpose. The purpose of the law, or whatever it's doing, the purpose has to be secular, it can't be religious. The principal effect of the law can neither advance nor inhibit religion. Now, sometimes you pass a law and it has a secular purpose, and it sort of accidentally or incidentally helps religion. Well, that's okay, but as long as it's not the purpose, that the principal effect is not to advance religion, then it's okay. And thirdly, it must not foster an excessive government entanglement with religion, where government is having to step in and decides what's orthodox or what's not, or if there's too much entanglement. There's always going to be some sort of overlap, but we want to minimize that and minimize the entanglement. So that's Lemon v. Kurtzman, 1971, also known as the Lemon test. Now, the court doesn't always follow this test anymore. Sometimes it does, sometimes it doesn't. We'll see as we examine these cases.
Okay. I think it's important to point out with respect to the Lemon test and the Establishment Clause generally, that it's always a restriction upon government. Christians sometimes complain that atheists who want to enforce the Establishment Clause are trying to infringe upon their exercise of religion, when that's never the case. It's always a restriction upon government rather than individuals.
Right. The Lemon test says what the government can and cannot do. What religion wants to do is protected by free speech, free assembly. So as long as there's no entanglement between government and religion, religion can do, pretty much what it wants to do. Not child sacrifice, but within some reasonable limits.
Okay, so what generally are the areas in which we find cases of government entanglement?
Well, some of the general areas are displays and expression of religion on public property, 10 Commandments, nativity scenes, things like that. Government funding of religion, and lastly, public education. There's a lot of court vouchers, things like that. In this part 1, we'll just discuss the first 2 areas, and we'll save the public education because there's a lot of cases just on that for part 2.
Okay, very good. Now, let's start off with legislatures and city councils, government bodies, opening their public sessions with prayer. What guidelines have the courts provided for that?
Well, there's a case called Marsh v. Chambers from 1983, and the Nebraska legislature would open its sessions with a chaplain chosen by the state, paid for with public funds. And this was challenged by a member of the Nebraska legislature, Ernest Chambers, who actually is an atheist. He challenges, saying, this is unconstitutional. And the Supreme Court sort of ignored the Lemon Law for entanglement and establishment and said, well, it's historic precedence, that this has been going on since the First Continental Congress, and the first Congress that we had these chaplains, and so they sort of grandfathered it in historically, totally ignored the Lemon test. In Minnesota, the idea, we have these prayers in Minnesota that the legislature, and the idea is that these are provided at before the session officially starts, so it's not an official time, and it's at the request of the legislators to serve their needs, and that's the reasoning in Minnesota.
I wonder if there are always provisions made for people not to attend during the prayer, but to come in and be seated when it's over?
Yeah, I think so. I witnessed one of these, and it did seem to me that you could skip the prayer if you wanted to, and that would make it voluntary. It's interesting, and these cases are always coming up. Just a couple days ago, Fredericksburg, Virginia, their city council said, we're going to have prayers, but the prayers have to be non-sectarian. They can't be specifically to Jesus or Christian. They have to be like a general God.
Okay.
That was their rule. Someone challenged it, evidently wanting to pray to a specific God. And the Supreme Court rejected that appeal, which essentially says, yeah, the city can make such a restriction that the prayer has to be generic. And the Supreme Court did not decide to take up that case, so it's okay then for legislative bodies to specifically say, you can have a prayer, but it has to be non-sectarian. And so far, that's okay.
All right, so you're saying that the specific government body can require sectarian prayers.
Non-sectarian.
Non-sectarian prayers. But the courts are not requiring that there be only non-sectarian prayers. Is that the case? So that if in some body a chaplain opened with asking for guidance in Jesus' name, and if the council itself didn't object, would it be all right?
I think so, because there are a lot of examples of this happening, and I haven't heard of it challenged. So I think if you did want to pray right to Jesus, you probably could. Like I say, I haven't heard the court come down on that.
I think there are cases in which it's being done that the FFRF is challenging right now.
They are challenging it. The court does apply a different standard when it's for young people in schools versus adults. We have seen that, and especially in this case where it's supposedly not on legislative time, it's before the session actually opens and it's voluntary, the legislators don't have to attend the prayer. There's usually more leniency for things like that.
And what about how the clergy or whoever they use to give these prayers are selected? Are they required to select from a broad base in the community?
I don't think they're required to. I think there's not legally required to.
Okay.
I know in Minnesota they make some slight effort, but as yet they haven't let an atheist give a secular invocation. We're working on it.
All right. Let's hope that happens soon. All right. A lot of cases occur with religious displays on government property. Now, there have been some big cases a couple of years ago, and actually quite a few before that, concerning Ten Commandments monuments in public property. And there are a lot of those because there was a movie that came out in the 1950s, The Ten Commandments, with Charlton Heston. And as part of the promotion for that movie, they gave out to a lot of communities monuments of Ten Commandments for them to erect on their public grounds. So what are the rules concerning that?
Well, the Supreme Court reached two opposite decisions on that in 2005. There was a case called Van Orden versus Perry, came out of Texas. Now this is the case where it was the federal, the Capitol grounds outside the Texas State Capitol, the grounds, and there were a total of 17 monuments and 21 historical markers on these grounds, including one of which was the Ten Commandments, and it had been there for about 40 years. And the Supreme Court said, well, that's part of a general display, and nobody looking at that would think that it's government promotion of religion. It's kind of historical. And besides, no one's complained. Why that should matter, and what chance an atheist in Texas would have, or anyone to complain, intimidation doesn't seem to have factored into their equation. But anyway, that was one of their arguments, is that, well, it's been there a long time, and we'll see this come into play in a bit as to how long something's been around. But I think it was the context, it was outside, it was amongst a lot of different monuments, and so by a 5-4 decision, they said, oh, that's okay. Well, at the very same time, they looked at another case, McCreary County versus ACLU, and this is a case in Kentucky. And this is where the Ten Commandments were on display inside a courthouse. And at first, they put up just the Ten Commandments. Well, and this was pretty recently that they had put it up. So again, this time element comes in, whether it's like historical, it's been up a long time or not. So they put up just the Ten Commandments. And so I said, well, that's obvious promotion of religion. Oh, well, then they put up a few other documents that had religious phrases in them to try to spread it out a little. And then, well, it was still an obvious promotion of religion. So then they put up some other stuff to try to make it seem like it was a secular display. But when the court looked at that, they said, well, you know, the history of this is obviously was to promote religion, and you're trying to water it down, but you can't hide the fact that that was the history, that was the purpose of why you tried to do that. So by 5-4, they said, no, you have to take that down. So why one, 10 commandments would be seen as promoting religion and another would be seen as not promoting religion? It's kind of a mixed bag. It kind of shows you that the Supreme Court often seems to follow public opinion. Maybe they kind of knew that they really should dump them all, but they could never get away with that. So they said, well, sometimes yes and sometimes no. And
I think there may be other factors in play too. When in determining the purpose of putting up the monument, they often look at the actual transcripts of what was said in city council meetings or public statements that the mayor or council people made to the press. And if it can be demonstrated from those sources that there was a religious purpose for constructing it, then the court can say the purpose is religious. Whereas if we're talking about something that was put up 40 years ago, you're probably not going to have the same, be able to apply the same argument.
And, case in point, in a town called Stigler, Oklahoma, they put up a 10 Commandments monument, but it was put up in 2004, so it didn't have that long history. And at the time it was put up, the county commissioner said, I'm a Christian and I believe in this, I think it's a benefit to the community.
Okay.
So a lower court said, no, this is obviously was put up for a religious purpose, you got to take it down. And the Supreme Court declined to hear that case. So those 10 Commandment monuments have to go because there was a documented history of a religious purpose for them.
Okay, and I think there's a lesson too for secularists in our audience who might be offended by some public display of religious symbols, that it's important to object, that not to wait until someone finally comes along to do so. Because if you wait 30 or 40 years, the point may be moot, or it may be much more difficult to make a case that that to the average viewer, to a normal person, that it's an offense right. to religious separation.
Yeah, good point, because that is kind of a standard that the Supreme Court is using now. How does this appear to the average viewer? And if an average viewer complains right away, well, then you have more standing, I think.
Okay. Now, besides 10 Commandments monuments, another type of religious symbol that we see a lot comes at Christmas time. Cities like to decorate themselves for the holiday season, and sometimes part of the display may be religious. What are the guidelines that cover that?
Right, the nativity scene, Mary and Joseph and Jesus, the baby Jesus. Well, we have a couple decisions on that. In 1983, in a case called Lynch versus Donhelly, in Pawtucket, Rhode Island, they had a Christmas display, and it had a crash, the nativity scene. But it also had a Santa Claus house, a Christmas tree, a banner that said season's greetings, and some other things. And the court said that since you had all these things, it's sort of like a generic holiday celebration. It's not a promotion of religion. It's just talking sort of like the historical origins of the holiday, and the display had a legitimate secular purpose. So that was the ruling in 1983. Okay. Then in 1989, in a case called Allegheny versus ACLU, they looked at it again. There was in Pittsburgh, Pennsylvania, inside, I think it was the courthouse. Yes, it was the courthouse. There was a huge nativity scene, and under it was a sign, Gloria in excelsis Deo, glory to God in the highest. which is a very Christian-associated phrase. So you just had a very specific religious display, nothing else near it. And the Supreme Court said, well, this is an obvious promotion of religion on government property in the government courthouse. Now, on the other hand, in another government building, there was a large Hanukkah menorah, and there was a Christmas tree, and then a sign that said, "Salute to Liberty." Well, I guess these other couple things were enough to secularize the display, and so that was okay. So there came to be something called the plastic reindeer rule. Okay. That if you want to put up a menorah or a nativity scene, you've got to throw in some secular stuff too, a plastic reindeer, and to make it secular. And in fact, the Freedom from Religion Foundation has a secular winter solstice sign that they're putting up. The idea was that this government property is a free speech area where many expressions can be put up, not just Christian, not just Jewish, but it's sort of a public forum is how they're legitimizing it. And so if you're going to allow all expression, you've got to allow atheist expression too. And so the Freedom from Religion Foundation has been able to put up their secular sign in many cities.
Yeah. Now, Christmas, of course, is such a secularized holiday. And, of course, I think everybody loves Christmas. Children love Christmas, and it's a time for presents and family and all of that. And I doubt that many atheists have a problem with that. But Christians feel, well, you're ignoring or eliminating the religious significance of the holiday season. And I think that it does. I can understand why they see it that way, because attacks that might be brought in court are usually going to be against Christians rather than against, for example, the Jewish menorah, because it's really only the Christians in this country that try to put their religious identity as a stamp upon government action.
Right. The reason Hanukkah has largely maintained its religious nature is because the Jews have not tried to force it on everybody else.
Right.
So that's a real good example of how separation of religion and government can benefit religion. You can keep it pure, you can do the ceremonies you want, it doesn't become secularized, or at least it's under your control. So how about public office now? Can God belief be used as a requirement for public office? Of course, there's the federal case, but also think about state and local issues. Right. The U.S. Constitution says that there shall be no religious test for public office or trust. Now, that originally just applied to the federal government. There are 6 states that have in their state constitutions requirements for God belief in order to hold public office or public trust. Public trust can be serving as a notary public, serving on the juries, for example. And Maryland is one of those states. And in 1961, in a case called Torcaso v. Watkins, Roy Torcaso was appointed as a notary public. He declined to take a religious oath. They tried to say, no, you can't serve. Took it to court, and in a unanimous decision, the Supreme Court said that neither a state nor the federal government can constitutionally force a person to profess a belief or disbelief in any religion. And then they cited the U.S. Constitution about no religious test for public office. And the court said that no citizen should be asked to sacrifice his constitutional liberties simply to hold public office. So public office, you know, that could be an elected public office, but when it says public trust, as I said, that's also serving on a jury, for example. So
what are the laws regarding that?
Yeah, so if you're serving on a jury, and this has happened to many, it has happened to me, very often the default pledge to fulfill the law is a God oath, but you do have the right to ask for a secular oath without God. That is your right, because to say that you'll uphold the laws, so help me God, that's a God a God oath and a profession of belief in a God. The state cannot require you to profess that belief. It has to have the alternative. What we would like is to have the secular oath be the default oath. I mean, that's the way it should be. I was testifying in a case once, and as a witness, you have to promise to tell the truth. And and they tacked on this "so help me God." And I said I prefer a secular oath. And they didn't know what I was talking about. Usually they do know what you're talking about and they have it ready. But this time they didn't. They somehow knew I was within my rights to ask for it, but they didn't know what to do. They were floundered. And so I said, they said, well, it's the only oath we have. And I said, well, how about if I promise to tell the truth under penalty of perjury, which is the secular punishment. God's not going to punish me, but yeah, the government will. They looked so relieved when I suggested that and proceeded to swear me under that oath.
That's interesting, and I am surprised that
that they didn't know.
They didn't know, because you would expect that these days to be
this is
very common.
Probably 20 years ago. With this incident, I was within my rights. Yeah. Sure.
Yeah. We only have a little bit of time left. I thought that we might mention the work being done by Michael Newdow, church-state separation. Are you among the people who helps Michael proofread his briefs for the court?
As I have time,
I
have helped him. He's trying to get the under God out of the Pledge of Allegiance.
Right.
So far, he's been denied standing, but he's found some other parents that would have standing. He's also trying to get religion out of the presidential inauguration.
That's right. Yep.
So those are two cases he's working on.
And curiously, even though the presidential inauguration has already occurred a year ago, the court case is proceeding forward.
Yeah.
So we may hear more of that. It's the Constitution specifies the presidential oath and does not include "So help me God" in it. And yet all the presidents since I think Hoover or before have included it. Well, we're coming to the end of tonight's program, and I want to thank you very much, August. If our viewers enjoyed this program, I hope they'll look for the next program in this series, which will be part 2. We'll discuss church-state separation laws with respect to education. And I hope that you'll come back to future programs and consider joining Minnesota Atheists. If you send to the contact information on the screens, your contact information, we'll send you one issue of our newsletter. And that's Minnesota Atheists, and getting to be quite a large and substantial newsletter for us. So thank you for watching, and if you're interested in us, we're interested in you.